brief session as far as I understand. It's 30 minutes duration, and the session is titled is Writing Research Articles in Law. I think I have navigated into a different mode because the whole program of yours is titled as legal journalism. So when it is titled as legal journalism, then naturally, whatever research content that could be used for writing articles, which in fact could fit into media. I think that should be the idea should be explored in that particular way. So I may not be sticking to the traditional requirement of writing academic articles, because that will not serve the purpose as the whole program, in fact, is focusing on legal journalism. See, when we talk about legal journalism, what makes me very, very exciting about reading newspapers, or rather going through the social media, having rich news content, is the different ways in which the legal happenings of this country is being reported. And often I find very funny snippets here and there, but quite often I find very, very contentful reading or material for reading through different social media platforms like Wire, Leaflet, and so many other things, print, etc., etc., and also through the traditional print media like various newspapers, which may focus on certain areas. So legal journalism, in fact, this particular topic has been chosen with much ingenuity by the LJRF, because this is another gate pathway for a law student to stretch his wings and to infuse whatever he had studied in the 5-year program or the 3-year program on a different pedestal, always remaining within that particular career wherein whatever he has invested in terms of 5-year or 3-year could be used, but you can reach out to a broader set of persons. What I find it quite exciting is that, see, if you become a lawyer, naturally you are in the litigation field. If you become a portfolio manager to a company, legal portfolio manager, then again you have got a cutout area of work, and the deliverables that the person engages you in that particular position expect you to deliver. But here you find you can your wings are quite stretched, and the person with ingenuity, a person with a little bit of reading, a person with research capabilities can always hone his skills or her skills, so that a wider readership can be subscribed, or there will be a larger subscribership to whatever stories that are being covered. But then I was in the inaugural session where Justice Sunil Thomas sir had spoken about the widening area, or rather the ever expanding area of the amalgam of law and journalism. It's really the amalgam of law and journalism. But then it stands apart from pure academic endeavors, literary endeavors, because writing an article in law, engaging legal research methods for an academic law journal, it's entirely different when you consider the complexion of the activity that a legal journalist engages in a routine manner. I think predominantly that day's discussion revolved around media reporting of court proceedings. But I think it is not limited to that. It's a wider canvas where one of the itineraries happen to be media reporting of court proceedings. But otherwise, whatever legal news that happens in and around us, need to be covered, because common man is looking forward for that particular news. Shift in the policies, a new policy being coming, transgender policy when it was rolled out by the government of Kerala, that became a news, because every law, behind every law there is a policy, and behind every policy there is a philosophy. So naturally what happens is that all these materials, whether it is uh, a perfect legal news or a full-fledged legal news or something on the borderline, covering all these aspects and the views, engaging the views also, not only news but views, isn't it? So in the matter of while you comment on certain legal developments, it's not simply news that is being radiated or that is being disseminated, but on the other hand, views are also being disseminated. So invariably, without knowing the engaging of research tools, a legal journalist who covers a court proceeding or who covers a legal news, maybe the tabling of a bill before a parliament or the state legislative assembly or something like that, uh, then the repercussions of that, the ramifications of that particular bill when it becomes an act, the legislative process that is involved, what happened in the parliament, what happened in the legislative assembly, Kerala legislative assembly while a bill was being piloted, whether some other what amendments were suggested, whether the amendments were put to vote. So they are exactly the legal process, the legislative process. In fact, legislative process is unfurled before the society, before the commoner, where apart along with that, almost all these legislative proceedings as well as now court proceedings are disseminated through the live stream. So common man gets an opportunity to break through the otherwise opaque walls of a legislative assembly or parliament or even the courtroom, and he can find, or he or she can witness as to what is happening, what are the transaction between a lawyer and a judge, what are being what's the response of a judge, isn't it? So, in fact, all these form part of the situations have changed, and by taking the aid of technology, all these otherwise opaque processes have become transparent, and it reaches out to the commoner. But then a commoner may not be able to understand uh, in a readily as to what's happening, what's the implication of raising a point of order, or rather, someone suggesting amendments to a bill that is being piloted, or a bill that is being what uh, given to the select committee for a better price, etc., etc. So that is where you find somebody who is engaged in covering these aspects need to inculcate, need to engage the research tools also, legal research tools, in fact, social science research tools. They may not be conscious about all these things because they will be interviewing persons. They will be what they will be searching the archives of that particular press or the media and finding as to the previous editions of this particular act or a particular decision that has been given by the court, or if it is between two countries, then again the transaction between these countries, or if it is a convention that is being given shape to by the United Nations, then how India act, whether India was a signatory or not, or what are the repercussions of that? Or when the United States stay away from the climate change summit, as to what will be the repercussions or ramifications of that staying apart, isn't it? So just like that. So a person who elects to report the proceedings or to give larger in-depth comments on certain legal developments need to engage research tools as well. Because there, I think the complexion changes. The product, in fact, determines the product that ultimately comes out determines the demand of engagement of research tools. Suppose it's a lawyer writing in the media, a law student writing in the media about a development, uh, and where doctrinal research techniques are being engaged as to precedents. What is the trend, judicial trend that the court was following all these days, and whether this particular judgment which came, latest judgment which came, whether the court, in fact, brushed aside all its earlier commitments. So whether that could be justified, whether it answers to the contemporary demands, situations, etc. So there, it's only not only the news, but also views should also be interpolated, and for that matter, to bring responsible content to writing serious content creation in law, or you can call it that particular manner, then we have to unmistakably engage the research tools that you have to find out the precedents, the trend of the court. Uh, because often we find in legal, in the Western media, uh, for example, the Supreme Court of the United States, under the Chief Justiceship, how the court has traversed or how the court has moved forward, whether there is an identifiable trend when Mr. X, the Chief Justice, led from the front, or whether that was in fact backtracking of certain issues, etc., etc. So we are living in a world where the opacity that was otherwise there in the matter of adjudication, litigation, rights, interpretation of laws, constitution, and so many other things, it's not the business of an elite class or a group, because ultimately the laws are made for human beings. So naturally, they have to come down and then get the subscribership of each and every commoner. Otherwise, see, if law is not internalized, if the justice content is not that much being reflected in while engaging law is there, naturally the people will revolt, isn't it? For example, last 2 days, I think in Haripad, in the district of Alleppey, uh, see, there was a public outrage on demolition of certain hills, and I learned that that particular move has been made by the revenue administration because of the strict instructions given by a single bench of the Kerala High Court. But then the public came down, and they in fact started to resist the revenue administration. And even though the first day the revenue administration used the police, they found that, see, it's not, it cannot be, they cannot sustain that particular pressure on a large cross section of people. Then the minister came and so many authorities came, and finally the collector uh, took a decision to stop that particular process, and then to inform the High Court that they have violated some formal procedures, etc., etc. See, that's the way in which people started to engage. Commoners have started to engage with legislative matters, with adjudicatory matters, etc. So there's a wider subscribership to all these news. So that is why serious content creation in the form of articles, in the form of reportings, etc., have largely come. So that is why I find that legal journalism, in fact, focuses on a major basis uh, the developments in legal, political topics and issues, and all these political, legal, and social issues are interconnected. So that is why a person who take to legal journalism, in fact, is involved in an amalgamation of a career in journalism and law, because journalistic writing is totally different from an academic writing. We used to always remind the students that, see, you cannot simply write a piece of information, or rather a paragraph, just as you see in the newspaper, because academic writing need a greater volume of substantiation, and also authenticity and authority. So that is where the overlapping consideration of journalistic writing and the legal content that is there in the uh, journal, in that particular writing character, is very, very important. So usually the journalistic writing, the hallmarks, we see the simplicity, that's a brevity or a precision, and the factual objectivity should be there. Then they should strike a balance between the, if two opposing views are there, And always the importance of newsworthiness is always on the pyramidal manner, inverted pyramid, because descending order of importance, etc. So a person who writes a content, legal content in a press, or rather in a social media platform, has to engage his skills as a journalist, as well as the skills that he has acquired while being a law student. So different content is there. So I think uh, while writing legal articles in media, apart from keeping aside all these other things, daily developments that is being covered, court proceedings that is being covered, I think much of the legal literature, much of the literature revolves around the daily court proceedings, isn't it? If it's a trial is being covered by a media, then what exactly the deposition of the how of the respective parties or witnesses, then how he was grilled, or what was the passing remarks of a judge, etc., etc. All these are daily beats in a reporting of daily beats in a court of law. But the entire methodology it's different, because no need of engaging research tools are there, because what they see they in fact reflect. And there we say that, see, you have to be very very responsible, because when you report, then that should be fair, that should be objective, and it should not it should not uh, okay, it should not trench into the it should not place any obstacles in the administration of justice process. So there, in fact, the conflict is very, very apparent. But when it comes to writing legal articles in media, selection of the topic is very, very important, isn't it? Very old topics, stale, obsolete topics may not fit in, because you need a readership. You need a wider subscribership to your article, isn't it? So selection of a topic is very, very important. And contemporaneous topics are to be preferred usually, or certain commemorative moments are there, then you have to collect material on retrospect, and then present it to re-engage the memories of people. Then obviously, otherwise, contemporaneous topics are being preferred, whether it is a piece of legislation and how it is going to affect the society, and or whether the legislative process is being sabotaged, etc., etc. Because while the infamous passage of the bills, isn't it, agriculture, with regard to what happened in the parliament, through a voice vote, the government in fact tried to pass the bill. They declared that bills were passed, and Rajya Sabha was disseminated, Council of States were disseminated. So all these things. So again, you find a legal question that which in fact is relevant to the masses is being canvassed, isn't it? Recently, the row between governors and the elected or the elected governments that happen in a cross section of states. Why usually a commoner is not that much interested, but then it is being discussed in different platforms, political platforms, then in so many other discussions, etc., etc. Slowly that percolates into the thinking process of an average human being. And because they only see the governor speeding past the in the road, or rather as a ceremonial head. But apart from that, in the daily legislative business, or in the while carrying forward the executive activities as a head of state, there is a role that is prescribed for him or for her, by the constitution. When these contestations are there, when these conflicts are there, when both the sides in fact come out in public, that and voices their concern, naturally the common man in the road, will always get to know certain things. Something is fishy, something is going on. So they will try to know, particularly in a state like Kerala, where we are very much conscious, politically conscious. We always think on the political correctness of decisions, etc., isn't it? So what I was telling you was that contemporaneous topics can be preferred, isn't it? Whether it's on court decisions, whether it's on legislations, policies, etc., etc. So the every day the scope of legal journalism is increasing. That is what I fine. That is broadcasting, whether it is podcast, whether it is broadcast or some other thing. And I'm more interested in the in legal writing of it. Okay, so where the academic legal writing is entirely different, where you are being subscribed by an informed group of persons who are very much interested in that particular intellectual exercise. But here, you have to step down from that humorous language that we have learned while reading the provisions of IPC, or whether in the matter of interpretation of various laws, decisions, etc. And then you have to simplify all these things and make it digestible, or make it what capable of being handled by a person who might not have gone to schools, but his sense of logic and common sense could be what answer to his demands of logic or common sense, isn't it? So in that particular manner, we have to simplify all these things. But again, the most important thing is that you cannot drown yourself in the hardcore legal research methods. But only thing is that our product, or rather the topic that we have selected to engage in a dialogue with the society, uh, we have to do justice to that. So even to a multi-layered society, multicultural society, etc., etc., somebody should be able to get hold of what you are saying, and that could generate views on that, maybe antagonistic views, or some views that are supportive of the content that is being transferred, etc. So anyway, that should give room for a discussion, isn't it? So what I want to tell you is that the career of a legal journalist, particularly creating content of a substantial content, that is interpretation of a decision, of decisions, legislations, policies, all these things. See that in fact, the present times is very much conducive for taking up these sort of challenges. Only thing is that we have to be judicious in selecting the topic on which we are going to engage in discussion. So that is where I find that contemporaneous topic has to be taken, uh, because people will be interested in the daily happenings. But that doesn't mean that some topics in retrospect cannot be chosen. For example, commemorative segments. Recently, we have celebrated the 50 years of the inception of basic structure doctrine through Keshavananda Bharati's case. Still, we are reeling under its impact, right? We are reeling under its impact. So many pieces of information, so many discussions, what remembrances, rendezvous, that is the meeting, interviews, and all these things have happened. So all even for content creation like that of an interview with a celebrated person, we have to do our homework, isn't it? So suppose you engage in the impact of Keshavananda Bharati after 50 years, and how exactly it has positively, progressively influenced the constitutional dynamics over a period of time, 50 years and thereafter. So there, the person, the legal journalist who is going to interview a celebrated person, need to do a homework. For that, again, he has to engage in research, isn't it? So legal journalism is a very important, or rather exciting area. Only thing is that we have to be very clear on what we are going to do, and how long it is going to sustain, what's the impact that is going to create, how we can make people excited, how we can excitement in the sense that it's not like effervescence, but how effectively we can transact certain information with the people who may be on the lower rung of a society, which for them apparently this may not matter, but originally all these things, all these legal developments will have certain repercussions, or rather will resonate with the common man's daily life, right? So we have to stay current. That is one particular area. And even you can find very serious content creators in law, particularly who engages the press as well as the social media as their vehicle for reflection of their thinking process. See, they might have developed an area of expertise, isn't it? So when they develop an area of expertise, naturally whether the present contemporary legal literature is having adequate information to that, or whether there are gaps or silences, etc. So that might have to be picked up. So again, for that you have to engage a wider literature review, and that is part of a research output. That's part of a research output. So whether the existing literature needs to be refurbished, whether it needs to, content should be added to that. That is one particular aspect which drives an enthusiastic legal journalist to engage in very serious discussions, isn't it? Then, so that is one area. Then exploring the controversial issues, isn't it? That is yet another area, because only through when you engage your vision through that particular tunnel, or you can say that a kaleidoscopic vision, you will be able to see the patterns that are unfurling before you. Otherwise, nobody will see anything special. So, what could be the impact of a particular law, a particular policy on the persons who are in the fundamental rungs of the society? Maybe to the ocean treaty that has been now drafted, how it can affect an average fisherman uh, uh, down in our coastal area, isn't it? Or whether a container terminal is being floated, the amalgam of development and sustenance, those areas. So where you find rich content of balancing act has to be done, where you cannot sit comfortable in the reclining chair of your cabin, but you have to go out. That is yet another, I think, what promising area for a journalist, because his feet will always be grounded, and he could easily come into terms with the functionalities of a legal system, and then weave and integrate it with the common lives of people, which you find many other, even academic may not be conversant about all these things. And because generally an academic, a conservative academic, will remain within certain bounded area, and he or she prefers to act upon those things and be prophetic about what could be thing. Whereas a journalist could reach out to persons and then find out. So, isn't it? So legal research tools can be used. May not be the journalist may not be very much conscious about the fact that when he interviews a person, when he collects data from a person, he is engaging certain tools, social science tools, which could ultimately cascade into the legal research area. May not be unknowingly. But then if he's a little more organized, then naturally productive output can be raised. Another aspect is you have to keep in mind the legal trends, isn't it? Uh, the legal trends that is there. Suppose, see, Virginia Airport, the recent one, where there's a stiff controversy is going on. On the one side, we are very much excited about the developments that it can bring to the state on a long-term benefits. But then there are erosion of the coastal area and so many other things, which the fisherman points out. Casualties, ever increasing casualties. So how to strike a chord? How to be a mediator? How to bring all these things? How to mainstream those things which otherwise get marginalized? See, uh, many of the striking areas have been brought forth by the journalists. So through a sustained contentful writing. So that is where a person has to have a hypothesis, isn't it? A clear hypothesis on that particular point, and then start engaging the collection of facts, then indexing of facts, then analyzing of the facts, figures, etc., etc., and then find out from the root causes of certain issues of a legal problem, and then can bring it on a balanced terms before the public at large, that nobody can just ignore these sort of fundamental investigation. So In all these areas, a gap or a knowledge base is going to be created. A policy concern is being reflected, isn't it? So, and a solution is being advanced. So in all these ways, a very effective journalistic legal content, uh, legally premised content with journalistic flavor can be put forward. I'll just 2 or 3 minutes I'll take to project one or two areas that I was just trying to show you. Um, okay. See, Krishnadas Rajagopal, I think you might have known, he needs no introduction. He's a legal correspondent in the Hindu. So there's everyday product. After the same-sex marriage, Supreme Court same-sex marriage verdicts acts as a formidable document upholding the Indianness of homosexuality and gender queerness. In fact, see, this is not a legal article, in fact, but this is more of the flavor of a reporting of that particular Supreme case that came before the Supreme Court. So there, what he says is that he acts as a mouthpiece, or rather a medium between the court and the reader, saying that the Chief Justice of India said this particular way, and the judgment, and he engages his intellect in that. Then Justice Sanjay Kishan Kaul said something like that. Likewise, and he explains all these things. That is more of a what? That is more of a reporting. This cannot be said as a an article, particularly a legal article, right? Okay. When I will show another thing. See, this is by I don't know whether you have come across this gentleman, Suhirt Parthasarathi. He's an advocate practicing in the Madras High Court. He regularly what responds to the legal developments that happen, particularly in this country, and he in fact regularly what writes. This is lastly. This is in the editorial page. This has come, but then this has got the flavor of an article because this again is this is based on the case that was decision delivered in October 16, X versus Union of India, where whether the viable fetus, about the aspect of a viable fetus versus woman's right. So contentious questions were answered there. See, if you just analyze this particular piece of writing, 95% it engages legal provisions. Okay, and also the adjudicatory dynamics, whether the court has had a sustained view or whether the court has refrained from its trend and brought in a different aspect. So where he in fact adds his own ideas as well. But then he engages a doctrinal research there. He discusses about MTP Act and the earlier decisions by this particular act, by the Supreme Court, and then whether they have expounded the right of the fetus as under Article 21 of the Constitution, etc., etc. And he's aligning with the view of one particular judge, Advocate Justice Nagaratna, where she said that a fetus cannot have a separate existence other than that of the mother. So the mother should get more the mother's claim should get more backing, because you might be reminded of the fact that there was a fractured verdict, split judgment by two women judges, Justice Hima Kohli and Justice Nagaratna. So naturally, that is referred to the Chief Justice, and Chief Justice himself formed the brigade, and then he, in fact, found force with other. He aligned with the judgment of, I think, Justice Nagaratna. So, likewise, and he says that the judgment in Excess versus Union of India, which falls short of bestowing any explicit rights to the unborn, suffers from errors, isn't it? So when he came to this particular judgment by Suhirt, then naturally he had engaged a fair bit of dialogue, where 95 to 99% it's a legal literature, isn't it? So here, I think the question, the issue is that this may not cater to average man in the road, because this is largely applicable to the persons who are informed about the dynamics of the code. Just below that, there was another article, Artificial Intelligence and the Issue of Human Centricity in Copyright Law. This is by Arul George Curry, as an associate professor at the National Law School of India University. In fact, Arul George Curry was an alumnus of the government law college, Ernakulam. And thereafter, he studied LLM in Ulster, then went abroad, took his PhD, postdoctoral, came back to NLU Delhi, was associate professor in there, and then he came he now joined the NLSIU Bangalore. Here, he is not, in fact, discussing on a particular decision, even though he takes the cue from a decision. But generally, he, in fact, is engaging his readers in a discussion on the approach of the existing IP protections to work generated by artificial intelligence. Here again, you find this is a contentful, this is rich in content law, but may not ultimately cater to the the average individual, isn't it? So also, like last 16th, there was a decision. There was a discussion from Tulsi K. Raj. Her father is also a very famous advocate and a writer, a columnist, Kalishuram Raj. So Tulsi was discussing on same-sex marriage, and she also said that it was a grave error on the part of the courts of law, isn't it? So you have to differentiate between the content, isn't it? Whether that could be catered to an average person, or not, that is very, very important. But when it comes to certain democratic aspects, when it comes to the environmental aspect, when it comes to something that happens around us, the language that is to be used, the treatment that has to be given, so have to be differentially seen if it is to cater to a larger subscribership. Because legal journalists, in fact, we talk about Yeshoda singing Carnatic music, right? Carnatic music sung by Shamankudi Srinivasa here, or great personalities, may not be decipherable by a common man. But when Yeshoda started to sing Carnatic music with a little bit of improvisation, etc., it started to deliver to whom? To the average man. Even though I don't know Carnatic music, I simply relish to see Yeshoda singing, isn't it? Likewise, he has to. We have to remain as a bridge between a wider subscribership and a legal development, or rather something that is being that's on an emerging tone. So that's where the treatment matters. The treatment matters, because you go for a hardcore content, then naturally it adds to the value. It adds to value. It will be getting subscribership, but may not be decipherable to an average person. But if you can engage the discourses that the common man can digest, then your product will be much more subscribed, isn't it? And you can be a bridge to larger subscribership for a very important legal developments. So in that way also, we can differentiate between all this reading. And another thing that as law students you need to do is to find blog writing, where you have to be very quick. On daily developments, you can write blogs, etc., etc. I will always suggest you to subscribe to Indian Constitutional Law and Philosophy by Gautam Bhatia. That's having a wider subscribership, but it's a little more hardcore content for a law student. I meant for a law student. Okay, and then naturally you can develop that particular ability to quickly respond. That quick response may not have the wherewithal of an impeccably researched material. But again, these are all quick responses which will, as an aggregate, which will strengthen our thinking process and to deliver the products in quick succession, isn't it? So it adds to our legal, not only information, but responses, immediate responses to certain developments, which a law student need to do it conscientiously. I think in the brief period, I think I should end here. We will have other discussions, because learning is in continuum. It never gets stopped in one single stroke. Thank you.
you.